Hello everyone, this is Urvashi Chauhan. Welcome to Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Starting with an important update on the petitions challenging the dilution of Article 370. As you know, in August 2019, the Government of India revoked the special status or the autonomy granted under Article 370 of the Indian Constitution to the state of Jammu and Kashmir. A batch of petitions have been pending in the Supreme Court since December 2019, challenging the abrogation and the J&K Reorganization Act, which bifurcated Jammu and Kashmir into union territories of J&K and Ladakh. Today, the matter was listed for directions to complete the pre-hearing formalities. The Supreme Court will start the hearing on the matter from 2nd August. CJI Chandrachud said that the matters will be heard day to day except on Mondays and Fridays. Justices Sanjay Kishan Kaul, Sanjeev Khanna, B.R. Gawai and Surya Kant are the other members of the bench. Yesterday, the Union government had filed an affidavit regarding the present status of Jammu and Kashmir after the abrogation of its special status. CJI Chandrachud said that the affidavit will not have any bearing on the merits of the matter relating to the constitutionality. The bench has also directed that all written submissions and compilations should be filed by 27th July. Stay tuned with Livelaw as we keep you updated with each and every development on this pertinent issue. The Supreme Court today granted interim protection from arrest to an advocate in an FIR registered by the Manipur police alleging offences of sedition, conspiracy to wage war against India, etc. The FIR was registered after she took part in a fact-finding mission regarding Manipur violence and held a press conference as part of the National Federation of Indian Women. CPI leader and National Federation of Indian Women General Secretary Annie Raja and Nisha Sidhu are named as other accused persons in the FIR, which was lodged on a complaint by S. Liben Singh. The complainant took objection to the accused, terming the Manipur violence as state-sponsored. The court has listed the matter on 14th July and has directed for no coercive steps to be taken against the petitioner till 5 p.m. that day. The next update is regarding the power tussle going on between the Delhi government and the Lieutenant Governor. In January this year, the National Green Tribunal had issued an order naming Delhi Lieutenant Governor Vinay Kumar Saxena as the chairman of a high-level committee on Yamuna river pollution. The Delhi government moved the court with a plea that a domain expert should head the panel in the place of LG. The Supreme Court today stayed the NGT's direction. Senior advocate Dr. Abhishek Manu Singhvi, appearing for the Delhi government, argued that such a power would not even be given to a governor, let alone an LG, and that a domain expert should be the head. The court issued notice in the plea and stayed the operation of the order to the extent of the LG being appointed as the committee head. And now coming to a development from Uttar Pradesh regarding the Krishna Janambhoomi dispute. As you already know that in May this year, the Allahabad High Court had directed to transfer all pending suits relating to the Krishna Janambhoomi Shahi Idgah dispute from the Mathura court to itself. Consequently, the court had instructed the district judge of Mathura to compile a list of similar cases related to the subject matter and those related to it indirectly, either explicitly or implicitly. Now, a special leave petition has been filed in the Supreme Court challenging this decision. The petition is filed by a Committee of Management, Trust Shahi Masjid Idgah. The petition states that the transfer application was allowed by the High Court despite the fact that the proceedings in the suit from which the transfer application originated were stayed by the coordinate bench of the Allahabad High Court, and that the High Court transferred other suits also to itself, even though no transfer applications were filed for those. If you remember, recently a decision of the Allahabad High Court had made headlines and not for the right reasons. The High Court of Allahabad had actually passed an order in a bail application filed by the accused in a case of alleged rape through false promise of marriage. The accused had taken the defense that the marriage with the woman could not be performed as she was a manglik. The court had then directed the head of astrology department, Lucknow University, to determine if the alleged rape victim was actually a Manglik by examining her kundali. The Supreme Court vacation bench, comprising Justice Sudhanshu Dholia and Justice Pankaj Mittal, had stayed the order after taking suo motu cognizance. Today, the Apex Court disposed the matter on the submission of the counsel for the complainant and the state of Uttar Pradesh that the bail application filed by the accused was dismissed for non-prosecution, and hence the matter had become infructuous. You might not be aware of the common practice for extending the office term of directors of the Enforcement Directorate and other central probe agencies. The central government has been embroiled in a prolonged political controversy over its decision to extend Enforcement Directorate Chief Sanjay Kumar Mishra's tenure, who was first appointed in November 2018 and was set to retire in 2020, but his term has been extended multiple times. The Supreme Court was moved to examine the validity of extension. The Supreme Court today held as illegal the extension given for violating the mandate of the Supreme Court's 2021 judgment in the Common Cause case. The court said that he should not be given further extension. However, the court allowed him to continue in his post till 31st July. Noting that the scope of judicial review over legislation is very limited and that the appointments of these officers are made by a high-level committee, the court said that extension can be granted to high-level officials in the public interest and with reasons in writing. A three-judge bench of Justices B.R. Gawai, Vikram Nath and Sanjay Karol heard the batch of petitions challenging Mishra's appointment as well as recent amendment to the Central Vigilance Commission Act. I hope you remember the Lakhimpur Kheri violence case where 8 persons lost their lives in October 2021. 4 farmers who were in the group of protesters against the farm laws were allegedly mowed down by vehicles in the convoy of Ashish Mishra, son of Union Minister Ajay Mishra. 1 journalist also got killed in the incident. The driver of the vehicle and 2 BJP workers were allegedly lynched by the farmers in the counter violence. Separate trials are happening in the case and the counter case. The Supreme Court had earlier granted interim bail to Ashish Mishra and had asked him to leave Uttar Pradesh and Delhi and allowed him to enter the states only to attend the trial. Today, the Supreme Court extended the interim bail in light of the ongoing trial. The division bench of Justice Surya Kant and Justice Dipankar Datta took note of the submissions of senior advocate Mukul Rohtagi that the trial in the case was going well. In another update, the West Bengal High Court today came down heavily on the West Bengal State Election Commission regarding their apparent mismanagement of the Panchayat elections this year. A bench comprising Chief Justice T.S. Sivangnanam and Justice Hirannamai Bhattacharya today remarked that the High Court registry was receiving incessant barrage of complaints regarding rampant electoral malpractice and instances of deadly violence. Earlier, to ease the concerns on post-poll violence, the court had directed paramilitary forces to remain in West Bengal for 10 days after the declaration of results in the election process. The Election Commission today submitted a report by and large pertaining to the measures taken by it on the reports of violence. However, the advocate appearing for the petitioner in this matter said that a situation of terror was prevalent in the state. To read the full story, you can visit our website at livelaw.in. Next, in the Adani Hindenburg matter, the Supreme Court has inquired about the background of legislative changes introduced by SEBI in the regulatory framework. This was after Advocate Prashant Bhushan, appearing for a petitioner seeking probe into the Hindenburg allegations, pointed out that as per the expert committee, SEBI's investigation will not reach anywhere owing to their own amendments and changes made to the definition of various terms like opaque structure, related party, etc. The bench comprising CJI Chandrachud, Justice P.S. Narasimha and Justice Manoj Mishra has decided to hear the matter on August 14th, that is the extended deadline given by the Supreme Court to SEBI to complete its investigation. The Rajasthan High Court has directed the District Parole Advisory Committee, Jodhpur, to reconsider the application filed by self-styled godman and rape convict Asaram, seeking 20-day parole under the Rajasthan Prisoners Release on Parole Rules of 1958. The bench of Justice Vijay Bishnoi and Justice Yogendra Kumar Purohit directed for reconsideration while setting aside the committee's order, which rejected his application as per the provisions of the parole rules of 2021. The bench was dealing with the writ plea filed by Asaram challenging the rejection of his application. It was contended that he was convicted and sentenced in April 2018. In contrast, the rules of 2021 came into effect in June 2021. Thus, his application for parole was liable to be considered under the 1958 parole rules and not as per provisions of the rules of 2021. Allowing his writ plea, the court directed the respondents to consider Asaram's application for releasing him on 20 days parole afresh in accordance with the provisions of the rules of 1958 within a period of 6 weeks. And lastly, the Delhi High Court has directed social media platform LinkedIn to provide details of its grievance officers and the relevant rules applicable to persons creating user profiles as per its policy. Justice Pratibha M. Singh also directed LinkedIn to place on record the standard operating procedure followed by its grievance officers whenever a complaint or grievance is received under the information technology rules. The court was hearing a suit filed by Tata Play Limited in 2020, which sought a decree of permanent injunction restraining LinkedIn from allowing any user on its platform from using the trademark Tata Sky. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share, and subscribe and support us.